I have presided over thousands of cases. I have watched people lose fortunes, reputations, businesses, and sometimes entire families inside a courtroom. I have listened to skilled liars, brilliant manipulators, and angry individuals who believed volume could overpower facts. But there is one woman I still remember with unusual clarity, not because she won, not because she lost, but because she threatened to sue the judge. And 47 seconds later, the entire courtroom turned against her. Her name was Karen Bennett. And the moment she walked into my courtroom, I knew she was not there to resolve a dispute. She was there to dominate one. Believe me, after enough years on the bench, you develop instincts that are difficult to explain. Sometimes a person enters the room carrying a certain energy. Not confidence, not courage control. Karen carried control. She wore a tailored navy blazer, expensive jewelry, and the expression of someone who expected every room to rearrange itself around her opinions. Her chin remained slightly raised as she approached the defendant's table, and she never once looked nervous. That caught my attention immediately. Most people feel at least some pressure inside a courtroom. Karen felt none. Across from her sat Daniel Carter, a small business owner in his early 40s. He looked exhausted. His suit was wrinkled. His eyes were heavy. There was something about him that suggested months of stress and sleepless nights. He kept reviewing documents even while Karen settled into her seat. That told me something too. People preparing for a performance watch the audience. People preparing for a fight review the facts. The dispute itself appeared straightforward. Karen claimed Daniel's landscaping company had damaged her property during a backyard renovation project. She demanded substantial compensation, claiming negligence, emotional distress, and intentional misconduct. Daniel denied everything. According to him, Karen had repeatedly changed project requirements, refused final inspections, withheld payments, and then filed complaints after being confronted about unpaid invoices. On paper, it looked like an ordinary civil dispute. But experience has taught me that the most dangerous courtroom cases often begin looking ordinary. As proceedings started, I noticed something else. Karen wasn't paying attention to the evidence. She was paying attention to me. Every question I asked Daniel seemed to irritate her. Every clarification I requested made her visibly impatient. She kept tapping her fingers against the table, not from anxiety, from frustration. The frustration of someone unused to waiting. I asked Daniel to explain the project timeline. He carefully described months of work, submitted photographs, contracts, text messages, and payment records. Karen rolled her eyes repeatedly. Then she laughed, a short laugh, sharp. Dismissive, the kind of laugh people use when they want everyone else to know they consider themselves smarter than the conversation. I looked at her. "Ma'am, is something amusing?" Her smile widened. "No, Your Honor." But the smile remained. That smile bothered me because it wasn't nervous. It wasn't defensive. It was calculating. Years on the bench teach you to recognize different types of confidence. Honest confidence usually relaxes when facts appear. Bull confidence becomes more aggressive. Karen's confidence was becoming aggressive. As Daniel continued presenting evidence, I noticed members of the gallery beginning to exchange looks. They were seeing it too, the interruptions, the sighs, the visible contempt. Then Daniel produced something unexpected, a series of text messages. Messages allegedly sent by Karen during the final weeks of the project. Karen's expression changed instantly, only slightly. But I saw it the first crack. I asked Daniel to submit the messages. Before he could hand them over, Karen suddenly stood up. Fast, too fast. Her chair nearly tipped backward. The entire courtroom turned toward her, and then she said the sentence that changed everything. She pointed directly at me and said, "If this court accepts those messages, my attorneys will file a lawsuit against you personally." And suddenly, the room went completely silent. A courtroom silence can mean many things. Sometimes it means fear. Sometimes it means shock. Sometimes it means every person in the room has just realized not someone crossed a line they did not even know existed. When Karen Bennett threatened to sue me personally from the defendant's table, the silence that followed was not confusion. It was disbelief. Daniel Carter froze with the printed text messages still in his hand. The bailiff shifted his stance near the wall. A woman in the gallery covered her mouth, and Karen stood there as if she had just delivered the winning argument. That was the part that stayed with me. She was not embarrassed. She was proud. I looked at her calmly and said, "Mom, sit down." She did not. Instead, she lifted her chin higher. I'm serious, she said. I know my rights. That phrase is often used by people who have never taken the time to understand their responsibilities. I have heard it in eviction disputes, fraud claims, custody hearings, harassment cases, and business conflicts. And every time, the pattern is similar. The moment facts begin tightening around someone, they reach for a bigger threat. Karen did not want the evidence reviewed. She wanted the evidence feared. I said again, sit down. This time, slower, the courtroom understood the difference. Daniel lowered the messages onto the table, as if he did not want to move too quickly. He had the look of a man who had been dealing with Karen's threats long before she brought them into court, and that mattered. Courtrooms often reveal only the final act of a story, but body language shows the history behind it. Daniel was not shocked by Karen. He was tired of her. Karen finally sat, but she did it with visible contempt. Crossing her arms and staring at me like discipline was an insult. I asked Daniel to continue. His voice shook slightly at first, but then steadied. He explained that the landscaping project began as a simple backyard renovation. Patio stones, drainage correction, flower bed edging, and a small retaining wall. The contract was signed clearly. The price was agreed upon. The timeline was documented. But within the first week, Karen began changing the scope. She wanted different stones. Then a different wall height, then additional drainage, then weekend work. Then she demanded discounts because, in her words, good reviews are worth more than invoices. Daniel had brought emails, invoices, change orders, and photographs. Everything was organized in folders. Karen had brought anger. There is a difference. An organized person does not always tell the truth, but organization gives a court something to test. Anger gives a court only noise. Then Daniel handed over the text messages. I read the first one. Karen had written, "If you bill me for these changes, I'll make sure your business regrets it." The second message was worse. "I know people. One complaint from me and your reputation is finished." The third message made the gallery shift again. "Do what I want, or I'll bury you in legal fees." I looked at Karen. She was no longer smiling. I asked, "Did you send these messages?" She said, "They're taken out of context." That answer is always revealing. Not no. Not I never wrote that. Taken out of context, that means the words exist. The only remaining question is what kind of excuse will be built around them. Karen leaned forward and said, "He was disrespectful to me." Daniel quietly replied, "I asked to be paid." The simplicity of that answer landed harder than a speech. Then Daniel produced photographs taken at the completion of the project. The patio was level. The retaining wall looked clean. The drainage appeared functional. A final inspection report from an independent contractor stated the work was completed properly and that the later damage was likely caused by intentional water diversion or post-completion alteration. That phrase caught my attention. Intentional water diversion. I asked Daniel what it meant. He hesitated, then said, "Your Honor, I believe Mrs. Bennett damaged her own yard after I refused to waive the remaining balance." Karen laughed again, but this time it sounded forced. And as Daniel reached for one final folder, I saw her eyes move toward it with real fear, not anger fear. That was when I knew the lawsuit threat had not been confidence, it had been panic. And whatever was inside that final folder was the reason. When Daniel Carter reached for that final folder, Karen Bennett's entire posture changed. Her shoulders stiffened, her mouth tightened, her eyes followed his hand like a person watching a locked door about to open. I have seen that reaction many times. It is not the reaction of someone confused by false evidence. It is the reaction of someone who knows exactly what is coming and cannot stop it anymore. Daniel placed the folder on the table and said, "Your Honor, this is why she threatened me." Karen immediately spoke over him. "That folder is irrelevant." I looked at her. "You have not seen what is inside it." She said, "I don't need to." And there it was, another mistake. People who are innocent usually want evidence exposed. People who are hiding something want evidence dismissed before it breathes. Daniel opened the folder and removed a printed email chain. The messages were between Karen and her neighborhood homeowners association. In them, Karen complained that Daniel's company had ruined her yard, endangered nearby property, and refused to correct dangerous work. But the dates were the problem. Karen had sent the complaint before the alleged damage appeared, 48 hours before. The courtroom began to shift again. Not loudly, not dramatically, but you could feel minds changing. People were beginning to understand that this was not a customer defending herself. This was a woman building a trap. I asked Karen, How did you report damage before the damage existed? For the first time, she paused. That pause mattered. A person telling the truth usually has a memory. A person inventing truth has to manufacture one under pressure. Karen said, I must have confused the dates. Daniel shook his head. Then he submitted security camera stills from a neighboring property. The first image showed Karen standing near the side yard late at night. The second showed her dragging what appeared to be a garden hose toward the newly finished retaining wall. The third showed water running along the edge of the patio. And the fourth image showed her looking directly toward the neighbor's camera. That fourth image changed the room because she did not look surprised. She looked caught, Karen's voice sharpened. That proves nothing. But even her denial had lost weight. I asked Daniel how he obtained the images. He said a neighbor, Olivia Grant, contacted him after Karen began telling residents his company had destroyed the property. Olivia had checked her camera because she thought the damage story sounded strange. That is the thing about lies. They often survive in private, but they weaken when other honest people start comparing details. Karen turned toward the gallery as if searching for support. She found none. Then Daniel's attorney asked permission to call Olivia Grant as a witness. Karen objected before I finished granting permission. Again, too fast, Olivia stepped forward. She was a retired nurse, calm but visibly uncomfortable. She did not look like someone eager for drama. She looked like someone who wished she had never been dragged into Karen's orbit. She testified that Karen had approached her days before the hearing and said, if anyone asks, you didn't see anything near my yard that night. I watched Karen while Olivia spoke. No sadness, no shame. Only calculation, Olivia continued. She told me Daniel was a bad contractor and that if I supported him, she'd report my fence extension to the HOA. That was when Daniel looked down. Not because he was surprised, because another piece had finally been confirmed. Karen had threatened him. She had threatened a witness. She had threatened the court. The pattern was no longer hidden. It was standing in full view. I turned to Karen and asked, did you attempt to influence this witness? Karen leaned forward and said, I was protecting my property. But the words felt hollow now. Then Daniel quietly said, Your Honor, there's also audio. Karen's face changed again, more sharply this time. And in that instant, I knew the courtroom had not yet heard the worst of it. Video evidence changes a courtroom differently than paper does. A document can be questioned. A photograph can be explained, but a voice carries personality. It carries intent. It carries the confidence a person had before they knew anyone would hear them later. When Daniel Carter said there was audio, Karen Bennett's face lost its last trace of confidence, not because audio is always perfect, but because she knew what her own voice had said. I allowed the recording. Daniel's attorney explained that the audio came from Daniel's business phone system. Karen had left a voicemail 2 days after refusing to pay the final invoice. The courtroom speakers crackled softly. Then Karen's voice filled the room. Daniel, this is your last chance. Cancel the remaining balance. Send me an apology in writing, and I'll consider not making this worse for you. Daniel sat perfectly still. Karen stared at the table. The recording continued. I have dealt with men like you before. You think because you own a little company, you can disrespect someone like me. You have no idea what I can do. The gallery was silent now, not entertained, disturbed. Because threats sound different when they are no longer hidden inside someone's private phone. Then came the sentence that explained everything. If you make me come to court, I will make sure the judge knows you are dangerous. I watched Daniel close his eyes for a second, and I understood something about him then. He had not just been defending money. He had been defending his name. That is what people sometimes forget. A false accusation does not only attack a claim, it attacks a person's standing in the world, their business, their family, their sleep. Karen had not cared. She had treated reputation like a bargaining chip. I asked Karen, do you recognize your voice? She said nothing. That silence was an answer. Then finally she said, I was frustrated. Frustration. Another word people use when cruelty gets recorded. I told her, frustration does not explain threatening a witness. It does not explain threatening a business owner, and it certainly does not explain threatening this court. Her eyes lifted sharply. There it is, she said. Bias. That was her last remaining strategy. When facts failed, she attacked the process. I have seen that tactic many times. A person loses control of the evidence, so they claim the courtroom itself is unfair. It is not a defense. It is an escape attempt. But this time, the escape route had closed. Daniel's attorney produced one final item for this phase, a short video from Olivia Grant's doorbell camera. Karen was standing at Olivia's porch 2 nights before court. Her voice was clear. "You stay out of this, Olivia. You didn't see anything. And if you say you did, I'll make sure your HOA violations become everyone's business." Olivia looked down as the video played, embarrassed to have been threatened in front of strangers. Karen turned red, then she stood up again. "I am done with this," she said. The bailiff moved closer. I looked at Karen and said, "You will sit down." She pointed at me. "You're going to hear from my lawyer." And that was when Daniel quietly placed another sheet of paper on the table, a court filing, a previous case. Same county, same pattern. Karen had sued another contractor 2 years earlier. The claim had been dismissed after surveillance footage showed she had exaggerated damage and threatened a witness. The courtroom shifted. Now we were no longer looking at one bad day. We were looking at a pattern. Karen saw the document and whispered, "That was sealed." Daniel's attorney replied, "No, Mrs. Bennett. It was public record." And suddenly every threat she had made began to look smaller. Not powerful, predictable. I looked down at the paperwork, then back at Karen for the first time. She seemed to understand that the courtroom was not afraid of her lawsuit threat. The courtroom was studying it, and the next 47 seconds would decide whether she would leave with dignity or be shut down in front of everyone. There are moments on the bench when you do not need to raise your voice. You simply allow the record to speak. Karen Bennett had threatened Daniel Carter. She had threatened Olivia Grant. She had threatened the Homeowners Association. And then, when the evidence began exposing her, she threatened me. That was not legal confidence. That was a pattern of intimidation. I looked at the previous court filing again. Same type of complaint, same kind of contractor. Same accusation of damage after a payment dispute. Same sudden collapse when video evidence appeared. Karen stared at me, breathing hard through her nose. I could see she wanted to interrupt, but something in the room had changed. For the first time, Karen understood that every interruption was making her smaller, not stronger. I said, "Mrs. Bennett, you threatened this court with a personal lawsuit if I accepted relevant evidence." She leaned forward, "Because you were allowing him to lie." I held up one hand. "No, you threatened this court because evidence was about to be admitted that you did not want reviewed." That sentence landed heavily. Daniel looked down at his hands. Olivia sat in the witness chair, still visibly tense. The gallery was silent. I continued, "You may disagree with the ruling. You may appeal through lawful procedure. What you may not do is attempt to intimidate a court into excluding evidence." Karen's mouth opened. I stopped her before she spoke. "And you may not use the phrase, 'I know my rights' as a cover for threatening every person who does not obey you." That was the 47-second window from the moment she stood to threaten me to the moment the court record shut the threat down completely. 47 seconds. That was all it took for confidence built on fear to collapse under procedure. But then came the viral moment no one expected. Daniel's attorney asked permission to play the final voicemail. Karen went still, not angry, still. That kind of stillness is different. It is the stillness of someone hearing the lock click from the outside. I allowed it. Karen's voice came through the courtroom speakers again. "If the judge gives me trouble, I'll make it about bias. They always fold when you threaten them personally." The courtroom erupted. Gasps, whispers. A chair scraped against the floor. Even the bailiff looked at Karen with disbelief. Daniel's face changed from exhaustion to shock. Olivia covered her mouth, and Karen, the woman who had walked in acting untouchable, suddenly looked like she wanted to disappear. The recording continued. "You don't beat people by being right. You beat them by making the fight too expensive." That sentence revealed the entire case. Not a damaged yard, not emotional distress, not justice, a strategy. Karen had been using lawsuits the way other people use threats in a parking lot. Not to seek truth, but to exhaust anyone who challenged her. I looked at Daniel. His eyes were wet now, though he tried to hide it. That is something many men do in court. They swallow pain because they think dignity means staying emotionless. But I knew what I was seeing. Relief. Someone had finally said out loud what he had been living through. Karen suddenly stood and shouted, "That was private." I looked directly at her. "No, Mrs. Bennett, it was evidence." The room went silent again. She pointed at Daniel. "He ruined my reputation." I said, "No, your conduct did." And that was when the court shut her down completely. I dismissed her claim in full. I found her testimony unreliable. I accepted Daniel's counterclaim for unpaid invoices, documented losses, and costs related to defending against bad faith accusations. I also ordered the record forwarded for review regarding witness intimidation and potential misuse of civil filings. Karen's face twisted with rage. "You can't do this," she said. I looked at her calmly. I just did. For 1 second, nobody moved. Then Daniel exhaled like a man who had been holding his breath for months, but Karen was not finished. She grabbed her purse, turned toward the gallery, and said, "You all saw what happened here." And from the back row, Olivia Grant quietly answered, "Yes, we did." Olivia Grant's quiet words did more damage than any argument could have. Yes, we did. The courtroom understood exactly what she meant. They had seen Karen Bennett threaten a contractor. They had seen her attempt to silence a witness. They had seen her threaten a judge when the evidence turned against her. And finally, they had heard her own voice admit that lawsuits were not justice to her. They were weapons. Karen stood frozen near the table, her purse clutched in one hand, her face burning with anger and humiliation. But humiliation is not the same as injustice. That is a lesson many people never learn. Daniel Carter remained seated, staring at the documents in front of him like he still could not believe the fight was over. For months, Karen had made him feel like one false complaint could destroy everything he built. His business, his name, his confidence. And for what? Because he asked to be paid for work he completed. I looked at Daniel and said, "Mr. Carter, this court recognizes the work was completed according to the contract and supported by the evidence presented." His eyes lowered. He nodded once. Sometimes people do not need applause. They need the truth written into the record. Then I looked at Karen. "Mrs. Bennett, courts exist for disputes, not intimidation. The law is not a private weapon. It is not a tool to punish people who refuse to obey you." She said nothing for once. Silence served her better than another threat. I ordered the unpaid balance awarded to Daniel, along with documented costs and reasonable court expenses. I dismissed Karen's claims with prejudice. I also made clear that the evidence involving witness intimidation and threats would be referred for appropriate review. The bailiff escorted Karen from the courtroom after she refused to stop muttering about appeals, attorneys, and consequences. But this time, nobody looked afraid. That was the change. When Karen entered, the room bent around her energy. When she left, the room breathed again. Daniel packed his folders slowly. Olivia stepped down from the witness area, still shaken, but steadier than before. Before leaving, Daniel turned to her and said, "Thank you." She simply nodded. That moment mattered to me. Because truth often survives because one person decides not to stay silent. I have thought about that case many times, not because Karen threatened me. Judges are threatened more often than people think. But because she believed the threat itself was power, she believed fear could replace facts, she believed legal language could disguise bullying, and she believed everyone would fold if she made the fight painful enough. But courtrooms are built for moments like that, not perfect people, not perfect systems, but moments where evidence finally stands taller than intimidation. Karen Bennett came in promising lawsuits. She left with her own words on the record. And Daniel Carter left with something money could not fully restore, but justice could begin to repair: his name. That is the moral I carried from that day. Never confuse a loud threat with real authority. Never confuse legal language with truth. And never believe that someone is powerful just because they are willing to scare people. Because in the end, the courtroom does not answer to fear. It answers to evidence. And 47 seconds after Karen tried to threaten the bench, evidence shut her down.